Okay. Well, thank you, Beth Ann, for setting this up. And thank you, Mark and Sam, for joining. I'm David Kirk. I'm a partner at Troutman Pepper Locke, which is the most recent incarnation of the firm Troutman Sanders that I joined 25 years ago. It became Troutman, it was Troutman Sanders, then Troutman Pepper Hamilton Sanders, and then in January, we merged with the Locke Lord firm. So we've gone from about 200 attorneys when I joined in 99 up to over 1,600 at this point. We have offices, I think, in 30 different, we have 30 different offices. A couple are in, we have two in New York and we have two in the LA area, I believe. But I'm here in the Atlanta office. And I have a master's in city and regional planning master's degree, and a law degree. Before I went to law school, I worked at ARC or the Atlanta Regional Commission for 12 years in both land use and transportation. Worked on a number of things, including the transportation plan for the '96 Olympics, airport system plans for the Atlanta region, the long-term regional plan, those sorts of things, and then went to law school and have been here at Troutman for 25 years. My practice focuses mainly on land use and zoning. I've also done a lot of work in annexation, represent a couple of community improvement districts, have done some work on tax allocation districts, including the Beltline original redevelopment plan for that many years ago. Interestingly, my wife is a AICP member as well, and is the planning director for Avondale Estates. So if you ever have any business in Avondale Estates, be very nice to the planning director there. I am an attorney, so here's the fine print that you should look at. These are just my opinions. It's educational. I'm not your lawyer. It's not legal advice. And there's enough. That's enough for that. So we're going to jump into this. We probably will not go the entire hour and a half. That will give us some time for questions at the end. Should you have any, don't feel compelled to ask questions, but certainly feel free to ask questions. If you can put them in the chat, I think that's probably the best thing to do, and we'll hit those at the end. All right, let's get started. I like this quote. I always have. This was a quote that this was a case that came out when I was in graduate school, and my planning law professor really liked this and put it up in our class. And I certainly agree that if policemen have to know the Constitution, then certainly a planner, because the things we do affect people's lives and livelihoods and property and a whole lot of other things. Typically not life and death situations, though I am familiar with a few cases like that, unfortunately. But we have a great deal of impact on people's lives and livelihoods. And if you've ever been in a planning commission meeting where a controversial item has come up, you certainly know that people are very passionate about these sorts of things. So why do you need to know the Constitution? Well, because you want to pass the AICP exam, for one thing. And what I'm going to do today, hopefully, is give you some background. It's some thoughts on the process. It is not a substitute for in-depth study. There are a lot of study guides that are available, certainly a lot more than and a lot more easily accessible than when I took the AICP exam way back when you guys were probably either not even born or or in elementary school. And it's certainly not a survey of Georgia land use and zoning law. I occasionally give those sorts of presentations at statewide conferences. And so certainly once you get your AICP certification, you'll need to get your law credits. So maybe this coming fall you can get a law credit if I'm giving a presentation at our next conference. I'm going to try to examine some areas that are the focus for the test. I have not seen the test. I do not participate in the preparation of the test. I've heard anecdotally a few things about it, and hopefully that will I can pass those on to you, and that will be helpful. And then I'm going to identify some references and study resources that hopefully you'll find helpful. So, thoughts on the process. The old joke, how do you eat an elephant? One bite at a time. And that's how I suggest that you try to study for the test. Don't try to cram for it. Try to bite off manageable sections in a timely way, and consistently prepare yourself for the exam. When I was at ARC, I took the exam and I got my materials and went over to Georgia State University Library, which was across the street, and after work every day for an hour or so, most days, probably not Fridays, but most days went over and prep for the exam that way. So here's what we're going to focus on today. Just some general terminology from the legal profession, some of which you may be familiar with, some foundational legal principles and decisions. I'm going to talk a little bit about the statutory basis for planning, the legal context of the plan, and then ways that plans are implemented. So some general legal terminology. In a case, you typically have a plaintiff and a defendant. The plaintiff is the person that files the case. The defendant is the person or entity that against whom that case is filed. So if you see, Brown versus Board of Education, which is a famous Supreme Court case, Brown was the plaintiff. The Board of Education was the defendant. An appealable decision. Typically, in the planning context, that would be a zoning decision. That would be that can then be appealed to the Superior Court in the jurisdiction where that decision is made. And if a decision is made there that is either unfavorable to the plaintiff or defendant, and they wish to appeal that case, then it can go up to potentially to the Court of Appeals in the state, and even the Supreme Court of the state, and ultimately could go through the federal appellate system up to the U.S. Supreme Court. When you have a situation like that, the appellant is the appealing party who is bringing the case, and the appellee would be the entity that actually won below. The appellant is the person that lost below and wants to appeal to a higher authority. Constitution, statute, and ordinance. Every state and the United States, of course, has a constitution. Statutes are simply laws that are passed at a state or federal level, and then local laws are ordinances. A case, and you'll see this in some of the review materials. Probably the best one for law is put together by the APA's Planning and Law Division. and they will actually have a little section about the facts of the case and then the holding of the case. The facts are simply laying forth that the plaintiff asked for a rezoning or asked for some action by the local government. The local government denied it, and then the holding is the decision that is made by the court. A de novo proceeding is typical in the zoning context for a rezoning decision that's appealed. What that means is de novo is from the beginning or starting anew, or however you want to phrase it. In those sorts of situations, the plaintiff and the defendant can bring new evidence before the court to whom they're appealing. They can bring in expert witnesses, those sorts of things. And again, that's typically in a case involving a legislative type decision, which is what a zoning decision would be. A review on the record would typically arise in a case such as a variance, where the court simply reviews the record and only the record that was before the deciding body. So in a variance, the example of a variance, if that decision regarding the variance is appealed, essentially the record is sealed and then handed over to the court. There's no new evidence, and the court is simply looking at the question of whether there is some evidence to support the decision that was made at the local level or made lower. Jury trial or bench trial. In the jury, obviously a jury of your peers. That's very rare in a zoning case, but they do happen from time to time, where there's 6 or 12 or whatever the number is of individuals from the community who sit and hear the evidence and render a verdict. Bench trial, the judge is that person. And so there's no jury. It's just simply the evidence presented to the judge. That's typically the case in zoning related litigation. And in both of those cases, either the jury or the judge would be the finder of fact. They're the person that weighs the evidence, decides whether the evidence is sufficient or insufficient to support a case. We're going to talk about a lot of these, but just so you're familiar with some foundational legal principles. On the left, we have sort of the hierarchy of precedent or hierarchy of guidance on how cases would be decided. The U.S. Constitution obviously preempts all of the below. Every state has a constitution. You have federal laws and regulations, federal laws such as the Religious Land Use and Institutionalized Persons Act, the Telecommunications Act, the Fair Housing Act, those sorts of things, and then regulations that the individual agencies at the federal government will issue that provide clarification on how those laws are to be implemented. Similarly, at the state level, you have state laws and state regulations that come into play in the planning context. Even though this is not a specific, not Georgia specific, Georgia itself does not have a state enabling act with regard to planning and zoning. A number of states do. South Carolina, for instance, is one where they have a state zoning enabling act, and most of the zoning ordinances in a state like that are very similar because the state law and the regulations sort of prescribe what what goes into it and how that ordinance should work. Local ordinances, local zoning ordinances, local development regs. In some cases, like Georgia, not every jurisdiction has zoning. In Georgia, there's about a third of the counties do not have specific zoning, but they would have local ordinances with regard sometimes to things like landfills and telecommunication facilities or other things that in the development context that are that have specific impacts, or the local government has decided to issue regulations and requirements on. Case law are simply the cases that are brought. Lucas versus South Carolina Coastal Commission, those sorts of things. Those provide the clarification, if you will, on the gray areas that all the other things above it sometimes leave. It applies those principles to the facts of that case and provides guidance going forward. On the right-hand side, we have some foundational principles that flow from generally, for purposes of this conversation, we're going to be talking about generally U.S. constitutional issues, the due process, both procedural and substantive, and we're going to get into these as we're moving forward. Concept of equal protection, that is treating similarly situated parties the same, or having a very good reason to treat them differently. We're going to spend a fair amount of time on takings, because my sense is that may well be a focus area of the test, particularly given some recent decisions. And in takings, the question, there are a couple of questions that come into play. One's called the rational nexus test. In other words, does the decision by the local government or the action taken by the local government bear a rational nexus, a rational connection, if you will, to a legitimate governmental purpose? And then there's also the concept of rough proportionality. That typically comes into play when you're talking about conditions. Do the conditions that are placed on a zoning decision, are they roughly proportionate to the impact that development, if you will have on the community? And then there are a number of other things that I've lumped under First Amendment protections: the right to free expression, freedom of religion, freedom of speech, and those will, again, I'll talk a little bit more about those. So let's talk first about due process. Again, there are two different kinds. There's procedural due process, which stands for the concept that if the government is taking some action that will affect your property interest, that you have to be provided a notice, adequate notice, and an opportunity to be heard in a fair hearing by an impartial tribunal. And the tribunal would be, the local government, city council, county commission, whatever body is making that final decision. Substantive due process comes back to the question of whether there is a rational relationship between that action or that decision taken by the local government to some legitimate governmental purpose. And I'll talk a little bit more about that substantive due process in just a second. So procedural due process. That's why we put up signs. This is a particularly busy sign that I would not recommend uh, putting up in your jurisdiction, simply because it will cause people to stop by the side of the road and cause traffic problems. Um, but it's the reason we put up signs. It's the reason we in some jurisdictions you send out letters or postcards or something like that to neighbors who might be affected within a certain distance. It's the reason you have you advertise for and have one or more hearings before the Planning Commission, the City Council, County Commission, those sorts of bodies. And it's the reason why in those hearings you have adequate time for both the applicant and the opponents to make their case, to provide either their evidence or their opinions about the application that is before the local government. So is that, a couple of people have their cameras on. If you can nod, so that kind of makes sense. You want to make sure that if you're making a decision that people know about it and they have an adequate opportunity to have make their voice heard. So that's the concept. And here are a couple of cases. And again, these are just, you'll find these referenced in the APA's Planning and Law Division guide. And so, I won't spend a ton of time on these, but these are just some notable procedural due process decisions. This first one is Eubank versus the City of Richmond. And here you had an ordinance that basically allowed the owners of property along a road to impose the setback for new development on that road. It essentially allowed the existing neighbors to impose these setbacks through a petition on prospective future neighbors. And the concern the court here had was that this was not necessarily an impartial body that was making this decision, that there may be bias, there may be wrongful motives, and it also delegates a decision or delegates an action that rightfully should be made by the local government authority to citizens. Similarly, with the Roberge case that's cited below that, the local government ordinance only allowed for what they called the home for the aged and poor. You'll see the date of that case. It's a old case, so that's why the terminology is that. Essentially, sort of like we would have today with group homes, allow for the location of substitute the word group home for aged and poor, only with the consent of neighbors. And again, that's a unlawful delegation of authority. Certainly, it's okay to have community input, but the decision-making authority about whether a particular use should or should not go in a particular location should be made by the elected officials. And what they were doing here was sort of punting that decision to the neighbors, and the court saw that as an unlawful delegation of authority. Now, just very quickly, you'll see a set of numbers here: 226 U.S. 137. The U.S. means that's a United States Supreme Court case. And 226 is just the book it's in, and 137 is simply the page in that book on which the decision starts. But the important thing is this is a United States Supreme Court decision, so it should control and most of the decisions that I'm going to talk about are U.S. Supreme Court cases. Some more, this Lordship Park versus zoning appeals. Here, the decision, this involved, if I recall the facts of this correctly, there was a proposal to have waterfront lots approved, and in the draft plan that the community had, it actually showed that they wanted to have a road there in Connecticut along the coastline, and so they denied the proposal based on that draft plan, and the important word there is draft. A draft plan should have no legal status, because if any of you have prepared a draft plan, you know it can change before it's adopted. If they were relying on an adopted plan, the outcome may have been different. But the reliance on a draft plan that has not been formally adopted, had not been reviewed by the public, and the local government had not determined that adoption of that plan was in the public interest, that violates due process. Similarly, in the Welton v. Hamilton case, here there were no decision criteria for the Board of Appeals to make their decision, and because of that, the court determined that that's sort of an unbridled discretion given to the board, doesn't have any rules, and so if the city council, creates a planning commission or a board of zoning appeals, they need to also provide that body with guidelines and standards for decision making. Okay, so that's procedural due process. Let's move to substantive due process. And again, the question being asked there is whether the action taken by the government bears a rational relationship, and by that I mean a conceivable or believable or reasonable relationship to a legitimate governmental purpose. And you can see there a number of legitimate governmental purposes that the courts have cited in the past. If you go to your zoning ordinance, or frankly any ordinance that your local government passes, one of the first clauses in that will be, that we're taking this action to protect the health, safety, and welfare and property values, et cetera, of our community. And that is essentially saying this is a legitimate governmental purpose that we're taking action to protect, and then they'll enact the zoning ordinance or whatever ordinance is being voted on. So again, substantive due process, you have to have a legitimate governmental purpose, and the action has to have a rational relationship to that purpose. Couple of due process cases. This first one, again, you got to look at the date because a billboard in 1917 was very different than the billboards that you have now. And it was a particularly, back in 1917, a billboard was essentially, imagine a piece of wood like this and a piece of wood like this, and in between is just space, and then the message would be on that board. They're literally boards that were stacked up against each other in sort of a TP type fashion. And in between that, you could, the concerns there were you could have fires, you could have, trash and other things accumulate in there. You could have immoral practices, which I won't go into, and, loiterers and criminals lurking there between the sheets of plywood or whatever. And this was essentially seen as a commercial intrusion into a residential area. And the court actually found there that requiring the consent of the homeowners for those billboards in their residential areas that did not violate due process. Another case that I think is an important one, and probably has language in it similar to what you have in your local ordinances. Village of Belterre versus Barras. This involved the Village of Belterre, and adjacent to the village was the State University of New York at, I believe, Stony Brook. And the village council there was concerned about things like frat houses and apartment houses and things that you typically find in a college town where you have a house with 5 or 6 or 7 or 8 people living, and as a result, you could have more noise than usual. You could have more cars parked, more traffic, cars parked in the front yard, all sorts of other things. We've all been in college, so we know what we could do back in college. And the Village of Belterre was single family residential only. And as one way of dealing with this, the village defined family in the way that I think it was any number of individuals related by blood, marriage, or adoption, or no more than 2 unrelated individuals living and sharing kitchen facilities and living as a household. I think if you go and look at your local ordinances, most of them define family. Here in the ones I'm familiar with in Georgia, they range from 2 to 6 unrelated individuals, but there typically is a number that is determined by the local government to be a single family or a family. Certainly, the Village of Belterre could have done other things. They could have enacted noise ordinances. They could have enacted traffic ordinances, littering ordinances, all sorts of other things, but they chose to do it this way. And that's really sort of the real important point about substantive due process is it doesn't have to be the best way, not necessarily the way I would do it or you would do it to deal with this issue, but it has to have a rational relationship to that legitimate governmental purpose of protecting single family neighborhoods. Sort of what we call sometimes the straight face test. If you can go before a judge and say, Your Honor, we looked at the littering ordinance, we looked at the traffic ordinance, we looked at all sorts of other things, but based on our study and our consideration, we felt that limiting the definition of family to only 2 unrelated individuals was a reasonable way to deal with this. And courts give a lot of deference to local governments. They presume that an ordinance is valid, and they apply what's called a rational basis test to it. So if there's a rational relationship, a rational basis for the action, then that action typically will stand. Let's move on to equal protection. Again, as I said at the outset, the concept here is that you treat those that are similarly situated the same, or you make distinctions only on legitimate grounds. If you're making a distinction based on a fundamental right, such as the right of a family that's related by blood to live together, or a protected class, such as making distinctions based on race or religion or immigrant status or that sort of thing, that they're generally seen as unconstitutional unless there's a compelling reason for differing treatment. And courts are rarely find that there's a compelling reason for that different treatment. So let's look at a couple of cases here in that area. This is the Eubank case again. Not only did it violate due process, it also violated equal protection because, again, you're not. They didn't have a compelling reason for imposing those setbacks. It could be, again, based on some prejudice or bias by the neighbors. And then there's, this is one of the very important cases in planning law. It is the case that basically said that the mere enactment of a zoning ordinance that creates, different geographic districts, such as residential districts and commercial districts and industrial districts and high density residential and low density residential, et cetera, and then excludes certain uses from those districts, is a valid exercise of police power and does not violate due process or equal protection. So a couple important things here. One is this word, the mere enactment. This case was what was called a facial challenge. In other words, the case was not arguing that the application of a particular district to a particular piece of property was the problem. It was just the mere enactment, the passage of the zoning ordinance was seen by Ambler Realty as unconstitutional, and of course it was seen as by the courts and ultimately the U.S. Supreme Court as a valid exercise of the police power. So that's how we have that's why we have zoning. That's why we're allowed to have zoning. The cases that you typically will see have to do with the application of the zoning ordinance to a particular piece of property, but the mere enactment of a zoning ordinance, provided it's enacted following whatever procedures are required, is a valid exercise of the police power. So let's move on to takings. And again, I know I'm going through this pretty quickly. It's really an overview. It's not an in-depth dive into each one of these. It's just things that you should know for purposes of the test. Takings arise out of the 5th and 14th Amendment to the U.S. Constitution. The 5th Amendment basically says that you cannot take private property for public use without just compensation. The 14th Amendment extends those protections to state actions the 14th Amendments were post-Civil War amendment to the Constitution that was really meant to protect the rights of recently emancipated slaves, to make sure that they were treated fairly by state governments. The Pennsylvania coal case looked at basically laid out the question, if you will, of that a regulation that takes property without compensation, or a regulation goes too far if it takes property without compensation, excuse me, a little tongue-tied. And the question that the courts have grappled with ever since that time, back in 1922, was the question of how far is too far. So here's some important cases that you might want to make sure you're familiar with as we go forward. This Penn Central Transport versus City of New York was a 1978 case, and here there was a proposal that a office tower be built on top of Grand Central Station. That was rejected by the City of New York. Penn Central took them to court, and ultimately it was determined that it was not a compensable taking because they had a historic preservation plan, which was adopted. It was not a draft historic preservation plan. And City of New York also had a transfer of development rights or transfer of air rights program in place where the rights that otherwise would be on top of Grand Central Station to build a office tower could be transferred to another property in the city and sort of as a bonus to the development in that area. And out of Penn Central came what are clearly called the Penn Central factors, and they looked at a number of things: the economic impact on the plaintiff, the extent to which that regulation interfered with what the court called distinct investment-backed expectations. And here, the investment-backed expectations would be that we can buy Grand Central Station and put an office tower on top of it, or have the right to put an office tower on top of it. And the fact that you had the transfer of development rights, the court felt did not interfere unduly with the investment-backed expectations, because those could be sold to other developers in the city, get some economic benefit from that, and get a return on your investment. And then the character of the government action, the fact there was a comprehensive plan in place, and the fact that there was this transfer of development rights program in place, supported the action that the government did take. Here's another one that you should take note of. This is the First Evangelical Lutheran Church case. Here you had an interesting situation. The Lutheran Church had essentially a camp, a retreat center, if you will, that was damaged by a flood. And following the flood, the County of Los Angeles, excuse me, put in place a moratorium so that they could prepare a comprehensive sort of flood mitigation plan for the area. The church took the county to court. and said, well, because you're holding up, any use of our property, we can't go on there even to camp or picnic. So you've taken all of our property, so you owe us monetary damages. The Supreme Court, again, this is a U.S. Supreme Court case. Supreme Court said that, yes, that's true, that if you have a regulation, this moratorium is a regulation, and it results in taking all use of the property, then yes, you have to pay monetary damages. But the court, the U.S. Supreme Court remanded, that means sent it back to the lower court to make a determination of whether the actual taking had occurred through the enactment of this moratorium. And the lower court determined it had not, because the moratorium was for a specific use. It was for a specific time period, after which presumably the church would once again have access to and use of its property. Some other ones, the Nolan case. Here, the California Coastal Commission had a plan, a coastal plan for the entire state, and Nolan wanted to build a house. And in the location where Nolan wanted to build the house, the Coastal Commission, as part of their plan, required, the plan itself required that there be views maintained from the public right of way to the coast, to the Pacific Ocean. But what the Coastal Commission did as a condition or an exaction on Nolan when approving their plan is say, no, you have to provide physical access through your property to the Pacific Ocean. You have to essentially give some of your property as a public right of way. That was inconsistent with the plan, and the court established what we call the essential nexus test for exactions. And in other words, the nature of the exaction has to have an essential nexus to the impact of that proposed development. Let's skip down to the Dolan versus City of Tigard. That's in Oregon. And here you had a hardware store that was expanding, and the city required that, clearly there was some impact to this expansion, but what the city did was required a number of conditions having to do with providing land for a bikeway. It was against a stream area, and the court looked at the nature of those exactions, the nature of those conditions, and determined that they were out of proportion with the impact. And so the Dolan test is what's called the rough proportionality test, and that means you have to make sure that not only do you have to meet the Nolan test, that there's an essential nexus between the exaction and the impact, you also have to have that exaction be roughly proportional to the project impact. So Nolan and Dolan are important cases that stand for essential nexus and rough proportionality. You can't, you just can't ask for everything when you're asking for conditions. Those conditions have to be related to the impacts of the project and have to be proportional to that impact. The Lucas case, you go back to that first evangelical case where the court said, yes, if you take all use of the land, then you do have to pay compensation. And this was the case with the Lucas. Mr. Lucas bought two undeveloped lots on the Isle of Palms near Charleston. He wanted to build two houses there. Excuse me. Want to build a house on each of those lots, just like the houses that existed down the beach both ways. And the state of South Carolina, through the Coastal Council, passed a shore protection ordinance that basically moved this imaginary line from the front of his, beyond which you couldn't build a house, moved it from the front of his property toward the sea to the back of his property, such that following the enactment of the regulation, Mr. Lucas was prohibited by that regulation from doing anything on those lots. And ultimately, the U.S. Supreme Court determined this was a total taking of the economic use of his land. It's now called a Lucas-type taking, where regulation essentially extinguishes the economic value of the property. Sort of an interesting postscript that you probably will not find on the test is that the court said you have to compensate him. I think the compensation was roughly $1 million. And in order to raise that $1 million to pay Mr. Lucas what they owed him for taking his property, the South Carolina Coastal Council actually sold those two lots to a developer for about $1 million, and there are houses on that today. Another case regarding takings, this has to do with moratoria in the Lake Tahoe area. And again, you got the words, the mere enactment of a moratorium does not affect the taking of the property. Similar to that first, the Lutheran Church case. The moratorium was put in place to do a comprehensive land use plan for development around Lake Tahoe, which is if any of you have been there, it's a beautiful, very sort of fragile environment. It was a temporary moratorium to allow for the development of this land use plan, and therefore, ultimately, the U.S. Supreme Court, and this SCT is just a different reporter, a different book, but it's the same. It's the U.S. Supreme Court as well. Yeah, that just the mere enactment of a moratorium does not affect a categorical taking of property that requires compensation. Now, importantly, with a moratorium, you do have to have a purpose, a very an important stated purpose, and it has to be temporary. You can't just continue to have a moratorium forever. Otherwise, you're going to end up running counter to this case and having to provide compensation. Another takings case, and again, we're heavy on takings cases today. This Kuntz case arose out of the state of Florida in 2013, where basically I think it was the Water Management District demanded that Kuntz pay about $150,000 to upgrade ditches, replace culverts, those sorts of things, about 7 miles away from the property that was in question. Kuntz had offered to dedicate about 11 acres of a 15-acre property for conservation purposes, and the water management district, which required, which had the authority over that issue, required him instead to pay money for things that were far away from what, geographically far away from the property in question. And this stands for the couple of propositions. The second one, the Nolan and Dolan test, again, the rational nexus and rough proportionality tests apply to a monetary exaction as well as other sorts of exactions where the applicant is required to dedicate money or services, labor, those sorts of things. And what's interesting in this case is they said, if you do this, if you give us $150,000, we'll approve your permit. And he did not accept that permit, so they denied that permit. But it stands for the proposition that there's no offsite exception, if you will, to the takings clause. So even if something is denied, if you look at the reasons for that denial, being here that he refused to pay that $150,000 for something that arguably was unrelated to the specific impacts of his project, then that is not an exception to the takings clause. It's subject to the takings clause. So let's move from water management to raisins. This has to do with the actual physical taking of property by the government. Now, the government can take your property. There's a whole area of law related to what we call eminent domain, where the government can take your property for public purposes such as building a road, those sorts of things. And when that happens, the government obviously has to pay fair market value. And here, the U.S. Department of Agriculture required the Horns, who were raisin farmers, that's actually a job. They're raisin farmers, and the Department of Agriculture required the Horns to basically give the Department of Agriculture a significant portion of their crop every year, presumably to keep the price of raisins high enough that they were marketable. And this was what we call a physical takings case, where the government actually comes and seizes your property. This is yet another Supreme Court case. It's just a different citation. But the court said that just as you would have the takings clause apply to real property, it applies to physical taking of private property. And the quote out of that case is, the government has a categorical duty to pay just compensation when it takes your car, just as when it takes your home. Whoops. Now this is a very recent case, the Sheets case, and it has to do with exactions. It has to do with impact fees. And here, this was decided just last year, another U.S. Supreme Court case where the county of El Dorado imposed what they call a traffic impact fee of over $23,000 in order for Mr. Sheets to put up a prefab single-family home on a small piece of property in the county. And what the county had done was, in developing this impact fee ordinance, they basically said it's in this part of the county and it's a single family home, so therefore it's $23,420. It wasn't based on the specific traffic impacts that could be attributable to, again, a prefab single family home on a rural road that probably generated, 4 trips a day, and didn't really have a measurable impact on the traffic in the area. Mr. Sheets paid the fee in protest, and then, claimed that fee was in fact an unlawful exaction that violated both the rational nexus and the rough proportionality test in Nolan and Dolan. Now the lower courts, meaning the state courts and presumably the U.S. district and circuit courts related to California, held that Nolan and Dolan only applied to permit conditions that are administratively imposed. And again, we go back to this. There was I think I put it here. No, I didn't, but it was an impact fee ordinance that was passed that set this traffic impact fee. And what the lower court said is that Nolan and Dolan only apply that if you have a specific piece of property and you come up with a condition that's administratively imposed by staff and then the local government. That's the only place Nolan and Dolan apply, not to fees imposed through a legislative act. But the U.S. Supreme Court said nope. The takings clause, the Fifth Amendment takings clause, as applied through the Nolan rational nexus and Dolan rough proportionality test, doesn't distinguish between a legislative and administrative condition. So if you have an impact fee ordinance, you are now subject to the Nolan test and the Dolan test going forward. And there's a good article that was written by Chris Nelson. I think his Arthur C. Nelson, having to do with impact fees going forward from this Sheets case. Okay, we're finally getting away from takings. I know you guys are riveted by this discussion on takings, but we're going to move on to some other areas that again are likely, potentially on the test. Again, I don't know for sure, but potentially on the test. Cases having to do with First Amendment. Typically, freedom of speech is important for sign regulations, for ordinances related to signs, for ordinances related to adult entertainment. Freedom of religion typically is based, not only on First Amendment, but they're often based on the Religious Land Use Institutionalized Persons Act, which prohibits a substantial burden on religious exercise unless that regulation is the least restrictive way to further a compelling government interest. And ordinary zoning is typically not seen as a substantial burden. But the First Amendment comes into play when you're regulating religious facilities, signs, and adult entertainment. And the message for those is you can do that, you can regulate those things, but you have to do so carefully. And give me just a second. I'm going to cheat a little bit. Let me talk for just a second about the religious facilities. And what they mean by that is if you require any sort of place of public assembly to get, for instance, a special land use permit to consider the impacts of traffic and that sort of thing on the community, then that typically would be okay. If, on the other hand, you're limiting it to, churches only and, potentially specific types of religious facilities, then that's when you're going to run into trouble. So let's talk about a few of these. Regulating adult uses. The Coleman Young case is probably the first one that looked at the idea of distance requirements between adult uses, and distance in between those uses and between those uses and residential areas. And the important thing here is that there had been some study done on sort of the secondary effects of adult theaters, and found that when they were placed closely together, or when they were very near residential areas, they tended to have bad external effects, crime and prostitution and other things like that. And so that study formed the basis for these distance requirements. And I think a lot of local governments that impose these sorts of restrictions do so on the basis of either studies they've done or sort of general studies that have been done in other jurisdictions. So that was found not to violate the Equal Protection Clause, idea being that you've got a theater, and just because the theater shows adult content, the plaintiffs argued that violated the Equal Protection Clause because it treated them differently without a compelling reason. The courts disagreed, and they also argued that you're restraining their right of free expression. Again, the court disagreed, said, well, you can engage in your free expression. You just can't do it, next door to another similar type establishment, and you can't do it within X number of feet of a residential area, and that was not seen as a prior restraint. Hopefully you're all familiar with this. It's relatively recent in terms of the law. I mean, I've been showing you cases from almost more than 100 years ago. So 10 years ago is like yesterday in planning law, practically. Reed versus Town of Gilbert. Here, Pastor Reed was the pastor of a church that was what we call a storefront type church, held services in different locations every week, or on sort of a monthly basis, sort of rotated around to different locations within the town of Gilbert. And the town of Gilbert passed a sign ordinance, and I'm going to go forward to that for just a second, that sort of classified the time you could display your sign. And you see here that there was an ideological sign that said, the end of the world is near. You could do it. You could have that up all the time. If there was for an election, you could put it up 4.5 months ahead of time and take it down, 2 weeks after the election, and so on and so forth, down to a religious event. You had to you could not put the sign up any more than 12 hours prior to the religious event, and you had to take it down within 1 hour after the event concluded. Now, imagine that the religious event, Pastor Reed had his services start at at 10 in the morning. So he couldn't put it up, and that would be on Sunday morning. He couldn't put it up until 10 o'clock at night on Saturday. And obviously that creates an issue because no one's going to see it, and then has to take it down an hour after service is concluded. So going back, the Supreme Court basically said you cannot regulate a sign based on content. You can't regulate, and a regulation is content based if it applies to a particular speech, the topic discussed, or the idea or message expressed, and that ordinances that have different rules for signs based on the topic, the content, or the subject matter are content based, and they're subject to what we call strict scrutiny, which again means there's got to be a compelling reason for this, and it has to be narrowly tailored to serve that compelling governmental interest. And so this sort of rubric for signs was seen as content-based regulation because you had to read the sign to figure out how to regulate the sign. So you had to read the message on the sign, and in order to figure out which one of these slots you would put it in, and that is content-based and violates the First Amendment. So basic message there is if you have to read a sign to regulate it, you are violating the First Amendment. Okay, here's some other cases having to do with housing and exclusionary zoning. You'll see I highlighted this case because it is not a U.S. Supreme Court case. It's an important case. If you've had planning law in graduate school, the Mount Laurel decisions are very important and have to do with the fair share concept, but that arises out of the New Jersey Constitution. It is not a federal requirement that the community has to provide its fair share of low and moderate income housing. And in Mount Laurel, the township had a consistent practice of excluding low and moderate income housing in its jurisdiction, what they call a pattern and practice in excluding multifamily dwellings. So under the New Jersey Constitution, the New Jersey Superior Court, which is essentially the Supreme Court of the state of New Jersey, held that this violated the state constitution. Now, compare that to the Arlington Heights decision. This is, again, a U.S. Supreme Court decision. And the important thing here is that it determined that the village of Arlington Heights was regulating land use in a way that could have a disproportionate impact on the ability to provide low and moderate income housing, but that in order to violate the federal Constitution, you had to have a racially discriminatory intent or purpose, and that had to be clear either through the discussion by the local government or in some other way. Here's an important case in the area of eminent domain. Remember, I said that the government can take your property for a public purpose, but has to provide compensation. So this Kelo decision had to do with the city of New London was trying to attract, I think it was Pfizer, to do a corporate campus in downtown, because the city of New London had fallen on tough economic times and thought this would be the saving grace, was to have Pfizer come in and put their fancy new headquarters building there. And so they condemned a lot of land, the land that they couldn't buy outright. They condemned, including Miss Kilo's cute little pink house. And the question here was whether a public purpose, i.e., economic development, was essentially the same thing as public use. And the court determined that, in fact, a public purpose of economic development consistent with an economic development plan was essentially fit that public use requirement of the takings clause, even though this would be a private development. There was a case called Berman v. Parker back in the 1950s that related to a similar situation where, I believe it was in Washington, D.C. I may be wrong on that, so don't quote me, but there was an area that was blighted. There was a department store that was still doing pretty well in that area, but that too was condemned. And the area was slated for redevelopment, and the court determined that the public purpose for economic redevelopment satisfied that takings clause public use requirement. So Suzette Kelo is not it's not particularly distinguishable in that it didn't really create new law. What it did do, however, is because of the time in which the time in which the case was decided, it led to a lot of local governments and a lot of state governments around the country to require additional steps if land was being taken for a public purpose. For instance, here in Georgia, I think you now have to have a supermajority of a city council or county commission vote to acquire land for economic development purposes, rather than just a simple majority. But it created a bit of a backlash among folks that are interested in property rights. So we're going to jump around a little bit. As you see, we are jumping around a little bit, but just I'm trying to hit topics that may come up. Telecommunications law. I could give, and in fact have given, a 2-hour presentation on telecommunications law. So I have done a lot of that over the last 25 years. This was actually a case that involved the city of Roswell here in Georgia, where and involved a federal law, the Telecommunications Act of '96, which requires it has certain requirements for when you have to file a lawsuit if you're representing, say, the T-Mobile or Verizon or one of the carriers, and a cell tower was denied. You have 30 days from the date of the decision. And the question here was whether, and you have to state the why the decision was wrong in your complaint. And here, the city of Roswell denied a cell tower. They did not provide separate written notice of the denial. They didn't provide the reasons for that denial in a timely way to T-Mobile. So it sort of hampered T-Mobile's ability to file a suit challenging that denial. And what the courts basically says is you have to provide a written notice of the denial, to the applicant. You have to provide written reasons for the denial. You can't simply say, well, look at the record or something like that. They have to be issued, not necessarily in the same letter, though that makes a lot of sense, that you would say you're denied and here are the reasons why. But the court sort of curiously said, no, you don't have to put the reasons in the denial notice itself, but you have to state them with clarity in a written form that's issued essentially at the same time with the notice of denial. And City of Roswell did not do that, so they violated the Telecommunications Act. So if you're engaged in regulating telecommunications facilities, if there is a denial, you need to make sure that you provide that written notice and the reasons for the denial in a timely way to the applicant, because that 30-day period does not start until that is provided. Okay, talk a little bit about the statutory basis. I'm not going to go into a lot of detail about this. Statutes are simply laws, and you have a number of federal laws, federal regulations that affect transportation, that affect housing, community development block grant program, and other things. Like the Religious Land Use Institutionalized Persons Act, that sort of thing. So you might want to be familiar with some of those. You have, at the state level, you have constitutional provisions here in Georgia. The state constitution says local governments may exercise the power of zoning. In other states, they say shall. So it differs from state to state. We have a planning act here in Georgia. We have what's called the Zoning Procedures Law, which provides guidance on how you exercise the power of zoning procedurally, if your local government chooses to exercise that power. But again, as I said at the outset, not every jurisdiction in Georgia does that. And then a lot of states have model codes. South Carolina is the one I'm most familiar with. And you'll find that most local government zoning ordinances in the state of South Carolina look very similar, both in terms of, how the sections, how they're written, the procedures, those sorts of things. And then, going down to the local level, you might have the city charter or the city or county code of ordinances, which would provide that basis for planning and zoning. You have a zoning ordinance. Again, that's a local law that affects not only the practice of planning and zoning, but the substance of it. I've mentioned the police power a lot, and just to sort of summarize what the police power is, it's the power of the state to regulate and control my private behavior in order to protect and promote the greater public welfare. It's the basis for traffic regulations, litter regulations, building codes, those sorts of things that basically protects you from me and people like me, or protects us from each other and the bad things that we could do. That police power is delegated to counties and municipalities by the state. Here in Georgia, as I said, the state delegates to local governments the power to enact zoning ordinances for the protection of the health, safety, morals, convenience, general welfare, et cetera, of that jurisdiction. And the police power is essentially the power of the state to do all these things. through laws and regulation. Now, I said I didn't know what was on the test. This is the one exception. This has been on the test, and it's fairly obscure, so I'm kind of surprised it was on the test, but it was on the test a few years ago. The distinction between Dillon's rule and home rule. Georgia is a home rule state. Local governments have broad authority, power to do a lot of things. If there's no state regulation having to do with a subject, then local governments have broad authority to make their own, rules related to whatever that issue is. Dillon's rule, by comparison, it states that local governments have three types of powers. Those that are expressly granted typically by their charter, by state law, by state regulation. So they have that power. And then if you look at those powers, local governments also have powers that are necessarily or fairly implied that relate to their exercise of those expressly granted powers. And then those that are essential to the purpose of, says the corporation, that would mean the local government, that aren't simply convenient. So essential purposes, expressly granted purposes, and necessarily implied powers are those powers that local governments have if a state operates under what we call Dillon's rule. And if there's a doubt where the specific power has been granted, Dillon's rule says it has not. We're almost done, so we're getting close. So let's talk a little bit about the legal context of the plan. A plan, can either be authorized or required. A lot of regulations involving the grant of funds requires some sort of plan be prepared to justify the expenditure of those funds. Could be authorized by legislation, either at the federal, state, or local level. A land use plan, as you all know, does not control land use unless there's some specific reference in the zoning ordinance. And by that, I mean, the city of Atlanta, basically in their zoning ordinance, says that land may not be zoned in a way that is in conflict with the local land use plan. So if I were to take an application to the city of Atlanta, I would have to make sure that was consistent with the land use plan, or amend the land use plan. Some sort of finishing points on plan implementation. You have your zoning ordinances, which are used to implement plans, subdivision ordinances. Some jurisdictions have the Unified Development, the UDC or a UDO, and then housing ordinances. Here are the references that I mentioned earlier. AICP has a lot of really good references, particularly that foundational land use law case. Planning Magazine will often have timely articles on land use law. And you can see what these other ones are. So that is it. I see we have one person left on the seminar, and I appreciate you staying on. And if you have any questions, now would be the time. Do we have anything in the chat?
David, I will say we do have one from somebody who had to leave, but we can get the answer to him. It was from Mark Adams, and he said, I was going to ask this earlier, just to confirm. Federal laws and regulations hold less authority than state constitutions, correct?
Federal laws and regulations. No, that's not correct.
Okay.
In my opinion. I mean, if you are, I would, it'd be hard. It'd be interesting to sort of see what specifics he's thinking about. But, if you have a federal law like the Telecommunications Act that says, you have to uh, provide, the written notice of decision. You have to provide the reasons for denial. I can't imagine a state constitution. I guess you could say, well, the state constitution gives you broad authority for planning and zoning things, but that does not trump um, the federal law that requires you to do certain things.
Okay.
So I would say probably not, and encourage him to he's probably thinking of a specific issue that he's dealing with right now. So I'm happy to talk with him. So let him know that I'm happy to.
Okay. And I will direct him that you did address the question at the end of the session so that he can watch it once the recording is
Sure, but if he
published.
has other questions, he can. Yeah, anybody has any questions, they can reach out
Okay.
to me. Email's probably best.
Okay. Any other questions from anyone?
And I see I used the whole hour and a half.
You did.
Good for me. I usually do. It's like Murphy's Law. I just expand to, or the ideal gas principle is what it is. Expand to fill the space.
Any questions?
Hello, can you hear me?
Yes.
Oh, thank you so much for the presentation. I learned a lot. I wanted to know if there is like any environmental related law questions that might pop up in the
It's
exam.
possible. Maybe, I would look through the exam preparation materials that APA provides. There may be some questions about, NEPA, the National Environmental Policy Act, and NEPA review and that process. But I don't know for sure. It's been, I won't, 30 plus years since I took the AICP exam, and I have not been involved in preparing it. So I'm not able to speak from observation, but I would suggest that if you look through all of the prep materials that AICP provides, then you'd probably get a pretty good idea of what they might stress, if anything, from that point of view.
Okay, thank you so much. And thank you for your time.
Certainly good luck.
Thank you. Have a good day.
You
All
too.
right. Well, we will sign off and get this loaded onto the website in the next day or so. Thank you again so much, David, for always presenting and being willing to help everyone prepare for
My
the
pleasure.
exam.
My
Thank
pleasure.
you.
You take care.
Thanks. You too. Bye-bye.
Bye.